The telecommunication rules are being revised in the European Union. The question that I want to address today is, are the fundamentals of those rules right, or should they be changed? So I wanted to address three main things. What are the objectives of the rule? What are the principles of the rule? And how the institution framework is functioning. First, regarding the goals. What are the goals today? The first goal is to promote competition, because with competition you can have services which are provided in the most efficient way. It's also competition which will trigger the telecom company to invest in new network. The second objective is the internal market. We know that digital services need to scale up. That is why, for instance, in America or in China, we have so many internet platforms. And in Europe, we are a bit weak on that because we are good at inventing, bad at scaling up. So internal market is very, very important. And the last objective is to serve the interest of the EU citizen. Rules are there to serve us. Now the question that is being discussed in the European Parliament and between the ministers are, should we add a fourth objective, which is a connectivity objective? We know that with the development of Internet of Things, artificial intelligence, we will need strong digital network. And the question is, should we add that as a fourth objective in the rules? And I think we should. Then the question is, what are the principles behind the rule? The first principle, which is an important principle in European law, is the principle of non-discrimination, or what is often said, level playing field. What does it mean? It means that every services should be subject to the same rule. Your connection is through a fixed line, through a mobile line, through a Wi-Fi. Everything should be regulated in the same manner. Another very famous application of this principle is the net neutrality, which means that the internet service provider, your internet provider, could not discriminate between the different content you receive. Or, in other words, all bits are equal. So this is a very important principle. Now the question is, can this principle be applicable in a world where we need a gigabit society, which maybe need more fiber everywhere? And that's one of the contentious issues that is now being discussed by the Parliament and by the ministers. A second principle, which is also a very important principle in EU law, is the principle of proportionality, which means you apply the rule only when they are necessary, no more. So for instance, everyone should be able to provide a telecommunication service. You don't need a notarization for that, except of course if you need spectrum, for instance. There you need to buy the spectrum. Another application of that is that the access obligation, which is now imposed on most of the telecommunication operator in Europe, should be removed when competition is there, when, in a way, market force can replace regulation. A third application of this principle of proportionality regards universal service. Universal service ensures that every one of us has internet access at a price which is affordable. Now, if the market can provide that, fine. It's only when the market do not provide that that you need then the state to intervene. A third principle is the principle of legal certainty. Now, this principle is of course very, very important in an industry which is based on important investment which are long-term. You know, when you invest in fiber, it's for 30, 40 years, and you need to know in advance how you will be regulated. Otherwise, you will not invest. So this principle is very, very important. And how it is ensured in Europe? First, because we know the objective that the regulator will pursue. I've just talked about them before. Second, because they should apply methodology, economic methodology, which are well known, the antitrust methodology. And third, the European Commission, through some recommendation, may explain in advance how some aspect of regulation will be dealt with. For instance, the Commission recommend a certain approach to regulate termination rate, or a certain approach to regulate new generation network. All of that contribute to stimulate, all of that contribute to having more legal certainty and therefore stimulate investment. And the last principle I want to deal with you today is the fact that regulation, access regulation, is based on antitrust methodology. That was a big reform that was done in 2002 for different purposes. First, to make the rule more flexible, because antitrust principles are very flexible. Second, to make the rule more legally certain, because antitrust principles are based on more than 60 years of European case law. Third, because those principles are harmonized. So therefore, it will be applied in the same way whether you are in Ireland or in Bulgaria. And fourth, it will ease the transition towards the mere application of competition law, because, as we have seen before, once you have enough competition, you remove regulation and you just apply competition law. Now, the question that is raised today before the European Parliament and the Council of Ministers is whether those rules and those principles are fit in an oligopoly situation. Now, what is an oligopoly? Is where you have 2 or 3 players only. And the question is those principles fit for those kind of market settings? Now, let's turn to institutions. So first, it's important to understand that the rules in Europe are based on a kind of decision chain model. On the top, you have the legislators, first the European legislators, and then the national legislators, which are setting the principle, which are setting the objective and the process. And then, at the end of the chain, you have some regulatory authority. You have in each member state an independent regulatory authority, which should apply those principle, objective, and process to ensure that the objectives are achieved in the most efficient way. Now, this decision chain model is a very important one, which allows the law to be flexible enough to adapt to the important technological innovation that we have with the telecommunication sector. And that decision chain model has been upheld by the Court of Justice in several cases. Now, the problem is that in some cases, the legislator, so the European Parliament and the ministers, try to adopt more and more detailed rules which are putting into question that decision chain model. Now, this decision chain model is very much based on the implementation of the rule by the national regulatory authority. And it's important that those national regulatory authorities are independent from who? From the operator, obviously, but also from the political power, that they are accountable to who? To the political power, and also that their decision can be reviewed by a court, and are transparent in what they are doing. And the last issue, which is a very complex one, is when the EU should intervene and when the issue should be left to the member states, or in other words, the issue of subsidiarity. Now, for services which have a global or European dimension, like for instance, an app services, clearly you have a cross-border dimension. When Google, when Facebook is providing the services, they are providing for the whole Europe, even for the whole world. So there, it makes sense to regulate it at the European level. On the other hand, for local issue, like for instance, digging in the street to put fiber, then it could be left to the member states of the European Union. So in conclusion, I think that the the objective and the principle of the framework are sound and should be kept in the reform we will do.